So why are we here?
Your Honor, I have a motion for summary disposition this morning. If I can update the court on the procedural posture of the case.
Okay.
This essentially was a fee dispute initially. Mr. Dressler hired me to represent him on an HOA matter. He initially paid me $1,500 for the letter stage to communicate with the HOA. At some point, he decided he wanted to sue them. He then hired me to sue them, which was an additional $3,500 fee, which he paid $2,500 of. At some point, as is detailed in my motion, he decided he wanted to terminate my services. Of the $2,500 that he placed in, we had about $880 in fees. And so we offered to give him a refund in the amount of $600 and something, whatever the mathematical difference is. He and his daughter, who's present today, decided to yell and scream and cuss at my office and argue. And then, since they paid with a credit card, they did a chargeback on me. But before they did a chargeback, they filed this lawsuit because I refused to give them the full refund. And so they sued me. So when the chargeback dispute didn't go as we had hoped, they decided to non-sue me. So they filed a dismissal. Unfortunately for them, prior to the dismissal, I had filed a counterclaim against them for the unpaid legal fees. And that is what we are here on this morning, Judge. I did have a plea to jurisdiction that was filed related to their original case because of the amounts, but it's moot because they dismissed their claims against me. And so the only claim pending in front of the court today is my claim for legal fees that are still owed. And so, Judge, what we've done is obviously the motion, and I have a copy for the court if you
Okay. That's fine.
Attached to the motion, which is obviously akin to a motion for summary judgment, we have the invoice is as Exhibit 1, and then attached Exhibits 2 through 9 are copies of all the work that we did. And in my affidavit, which is attached as Exhibit 10, I go through each and every item that we worked on in the case and explain the time charges that are in the bill, and they correspond to Exhibit 1, and explain how we obtain those time charges. And so effectively, Judge, what we have is a detailed affidavit that complies with, it's now Ramirez case, which is the new Supreme Court case, which details, again, what you're supposed to do when you're proving up legal fees. Essentially, Your Honor, in the affidavit, we explain each exhibit, we explain the time charges, and then we go through the Ramirez factors relating to the hourly rate, what's charged in Dare County, whether it's reasonable and necessary, and we go through the services. Now, the amount that we're claiming in terms of a judgment and the damages is the $880 that's due based on the time charges that are seen in the original invoice. In addition to that, we have proved up an additional 15 hours of work related to defending and preparing these motions and preparing for today's in court. So we're asking for, in terms of legal fees related to the collection, we're asking for an additional 20 hours at $350 an hour, which is what my time charge is. I go through my qualifications. I've been licensed for 27 years.
I know.
So we're asking in order to collect the judgment because of being sued, having to defend, then getting dismissed, and then having to file all the motions that we've had to file to collect the $880. We're asking for an additional $7,000 in legal fees. I would point out also, Judge, just for the court, that under 503.2 of the Texas Rules of Civil Procedure, there's supposed to be a sworn response to this motion, much like a motion for summary judgment. None has been filed. There's no response been filed. And secondly, Your Honor, related to legal fees, the only way to challenge, and I have the case for the court, Your Honor, is through expert testimony. That is, they would have had to hire a lawyer to review my billing to say that is not what a Bexar County attorney would reasonably and necessarily charge for legal fees or you're charging too much, or I don't agree with this itemization. They did not do that. They are not qualified to testify and nitpick the bill. So any evidence or anything they tell you cannot be considered by the court as a matter of law because they're not qualified as an attorney and as an expert on this matter to dispute the bills and charges, Judge. So what we're asking for is the court to grant the summary disposition, grant a judgment in the amount of $880 for the legal fees that are still due to my office, and a judgment for $7,000 in reasonable and necessary legal fees as pled for in the affidavit and the motion, Judge.
Thank you. Yes, sir.
Total BS, man.
When we hired him, he was hired for $1,500 to get us a board meeting
Yes.
with the HOA. Because we had already been talking to them and been denied, and they said, your only thing to do at this point is to, within 30 days of the denial letter, get a meeting with the board. That never happened. In June, he told us he didn't have time for us again until September.
Well, you've already dismissed your.
Yeah,
your
because he
answer.
got the money back from
He's
the
already
credit
had
card.
$4
Yeah,
grand.
he has 4,000 from us already.
And
Actually-
Your Honor,
And
Actually,
the
it was-
whole matter got settled in one meeting. I attended a board meeting on my own, 45 minutes, and it's already settled. The variance has been filed.
Okay,
There's nothing.
all right.
I don't have $4,000 of their money. I have $1,500 of their money because they charged me back.
Yes, and the bank gave him the 2,500 back, and I have proof right here.
it's the paperwork
Yes.
Could you tender it to defendant, please?
from Security Service.
Let me see. No. There was 3 total. This is them originally crediting it. And then this one shows the one that they took it back from us. Because it's on my credit card too. It's mixed in with his
Isn't it
stuff.
on the Security Service?
Yes, but his stuff is mixed in with it.
Judge, if that is actually true, then they would be entitled to a refund. I've never seen that come through on my.
That's why I'm having to look. at it.
Yeah, I mean, I have, it's not on that one, on the other one, that's the one showing they credited, and there's another one showing that it got taken back out because the balance was changed. Wait a minute. I was looking in the. No, I have.
I would suggest to the court that I don't want to hurry them up and make them find something, because you can never find anything when you really need to find it.
I can find it.
And
It take very long.
Okay.
I just saw it. But he's not organized like a woman. That's the removal. Here's the removal, and then this one shows they put it back. Here's all of them right here. They all got reversed back to him. Cause our balance went from one thing to, it was like at 11,000, and then we saw the 25. See if I have another. I do have the one that shows the state as well. If not, I could provide it. Here's another one right there.
This one, he said we filed a amended petition.
Get it, you took it back. It's back in your account. It already came
Maybe you
out of my
didn't
account.
see it, but yes, it did come out of the account.
So you
They
need,
credited it and then gave it, they credited it on this day in 23 right here. They credited it, and then the next month when he filed that's when he filed against you to dismiss the case. And then right after that is when they credited it back.
Well, all I see is the amount being removed, Judge. I'd like to provide them the opportunity to provide me with the evidence it went back, because I certainly haven't seen that.
It says right here, we removed $2,500 charge from your account and notified you that this was a credit contingent. And then it shows right there that it went back.
But this is the original. This is the original dispute amount. I don't. 2,500 was retail.
I can go get a bank statement and provide it to you if that's needed to show that.
Sure, if you want to.
Yeah.
I'm happy to give them an opportunity to do that.
I can
Do you want to
email,
reset for a couple weeks or,
Please, Judge, so we can try to resolve.
okay, let's do that. Let me give you this back.
I can send you a copy of that.
Your age.
And I can get a
30
copy.
days, 2 weeks, what do you need?
Can we get 30 days, Judge,
30
just to be
days.
sure?
I can just email it. You just want it emailed to you?
Sure, just email me a copy of the minute statement.
Okay.
So I'll refund it back.
Perfect. Hopefully we can get this resolved.
Good, thank you.
Y'all have a good afternoon. It's gonna be reset for 30 days.
30 days.
Yeah,
30
so y'all can
days.
get your,
Okay, well.
So we can prove to him that he got the money
Okay,
back.
but I wanted to tell Your Honor that, you know, I only hired him, he and
I
I
know,
were friends, and it's kind of like it's blowing me away. And
okay, let's get
offered
that.
to
He already
do-
said if it's in his bank account, then
Give
y'all
it
can
a
get this
refund.
resolved, all right?
No, I know, just,
Okay, all
but
right.
the rest that he's charging me for, he didn't do
Just-
anything. Okay.
Come on.
30 days.
We'll discuss it. Thank you.
Okay.
May I excuse, John?
Yes, thank you.
Thank you.
Uh-huh.